since not all of us went to law school, I have put together a primer on things that are actually not up for debate. The first is Tennessee versus Garner. A 1985 Supreme Court case established that a police officer's use of deadly force is not justified simply because a suspect is fleeing and or not complying with an officer's order. An officer may only use deadly force to apprehend a fleeing suspect if the officer has probable cause to believe that the suspect poses a threat of serious physical harm either to the officer or others. And before you ask, a simple statement by an officer that he fears for his safety or the safety of others is not enough. There must be objective factors to justify such a concern. The Supreme Court unanimously in 2025 decided whether an officer used excessive force must be analyzed under an objective reasonableness standard, considering the totality of the circumstances, not just the moment of threat. This is how the objectively reasonable standard has applied to a police officer shooting at a moving vehicle. Cordova versus Aragon 2009, the 10th Circuit denied qualified immunity to an officer who shot at a fleeing suspect's vehicle. The Supreme Court standard in Garner does not mean that any risk of physical harm to others, no matter how slight, would justify any application of force, no matter how certain to cause death. Quote, "We do not believe it would be reasonable for an officer to shoot any motorist who ran a red light or swerved through lanes simply because reckless driving poses some threat of physical harm to a bystander who might be down the road." Quote, "When the officer employs such a level of force that death is nearly certain, he must do so based on more than the general dangers posed by reckless driving. The threat to the officer's safety must have been more than a mere possibility in order for the officer to have employed deadly force." Warren versus City of Tacoma, 9th Circuit 2020. An officer standing near a slow-moving vehicle would not have perceived himself to be in danger of serious bodily harm because he could have avoided any risk of injury by simply stepping to the side. The police officer could not have reasonably feared for his own safety because he was on the side of the suspect's vehicle as it was traveling away from him. Villanueva versus Cleveland, 9th Circuit 2021. The police officers argued that their use of excessive force was necessary, shooting into a vehicle which ultimately killed the driver. Because the vehicle itself was a deadly threat to officers, the court rejected this argument. Quote, "The truck was moving forward at a speed of up to 5 miles an hour when they shot at it," and quote, "The court has consistently found use of deadly force to stop a slow-moving vehicle unreasonable when the officers could have easily stepped out of the vehicle's path to avoid danger." Acosta versus City and County of San Francisco, 9th Circuit 2021, denying qualified immunity for police officer where he shot and killed a suspect in a moving vehicle. Quote, "A reasonable officer who had positioned himself facing the driver so that he was standing closer to the side than the dead center of the car would have recognized that he could avoid being injured when the car moved slowly by simply stepping to the side." Adam versus Spears, 9th Circuit 2007, denying qualified immunity for CHP officer Paul Spears, who shot and killed a fleeing suspect. After the suspect's car was stopped and surrounded, the suspect's car began rolling backwards because the suspect was attempting to reverse backwards, and CHP officer Spears shot into the car to allegedly stop him from fleeing. These cases that I've referenced are mostly 9th Circuit. That does not mean that it only applies to the 9th Circuit. It is applying the Supreme Court standards that were outlined in Tennessee versus Garner. This standard that the 9th Circuit is applying applies everywhere. I will note that every case that I have listed and mentioned involved an actual suspect of a crime, even if they did have probable cause to arrest this individual or reasonable suspicion enough to stop her. All of these standards would apply. Stop pretending this is normal and should have happened. Don't try to make arguments you don't understand and never were qualified to make in the first place. All of the cases I've pulled from and the excerpts you've seen in this video are linked in my bio. So if you'd like to argue with me, use that time to read the cases yourselves and maybe learn something first.